So hello, everyone, and welcome to ARBinBRIEF's Season 2 kickoff on regional diversity in international arbitration. For those of you who are new to ARBinBRIEF, ARBinBRIEF is a concise video guide on hand-picked arbitration issues presented by leading arbitrators in the field. And ARBinBRIEF is a project created in partnership with Delos Dispute Resolution and the ERA Pledge, the Equal Representation in Arbitration Pledge. And after a very successful first season, we're really excited to kick off Season 2. And to celebrate 1 year of ARBinBRIEF and to launch our second season, today's special event focuses on regional diversity in international arbitration. So before we begin, I just wanted to note for the audience that you can please feel free to put your questions in the chat using the Q&A function. And we will do our best to take them as we go. So now I have the great pleasure to introduce our excellent panelists for today. They hail from all different corners of the globe. First, we have Anna Gerdau. Anna is a senior associate at 𝗔𝗥𝗕𝗙𝗏 in Paris. She is Brazilian and German by nationality, and she started her career at law firms in Sao Paulo. She then moved to the UK to continue her higher studies. And then she continued her arbitration career in Paris, where she is currently based. And interestingly, she is one of the co-founders of the Rising Arbitrators Initiative. Next, we have Oluwaseun Philip-Idiok. Oluwaseun is a senior associate at ALEX in Lagos. She is Nigerian and she studied law in the UK before she returned to Nigeria to complete her legal training and start her successful practice as a disputes lawyer. Oluwaseun is the former co-chair of the Lagos Court of Arbitration's Young Arbitrators Network. Next, we're also thrilled to have May Tai. May is the managing partner of Herbert Smith Freehills Asia, and she's based in Hong Kong. She is Malaysian of Chinese origin, and she grew up in Malaysia and Indonesia. She studied and worked in England and later moved to Asia. And that includes mainland China, Japan, Singapore, and also Hong Kong, where she is now. And among the very many hats that she wears, May is on the board of advisors of Delos. And last but not least, we have Sara Aranjo. She is a partner at Al Tamimi and Company in Dubai. And she has a very international profile. She is admitted to the bar in Beirut, Paris, New York, and she has also lived and worked in many different places, including Lebanon, France, US, and England, in addition to the UAE, where she is currently. And true to her very international background, Sara is a member of the Swiss Arbitration Central Arbitration Court, as well as the ICC Court. So with that, you've seen that we have a very exceptional panel who will bring with them diverse perspectives on the topic. So I think we can just get started and dive straight in. And before we start talking about ways to improve regional diversity, which is really the focus of today's event, we need to understand a little bit about why we need to do so. So my first question, and Oluwaseun, perhaps you can start us off. How does the current landscape, so to speak, of regional diversity look to you?
Thank you. I would say that it's improved in the last 10 years, helped by arbitral institutions in different regions. And so we now have the Lagos Court of Arbitration, we have the Kigali Arbitration Center, there's an arbitration center in Mauritius as well. So for parties that are pursuing or more inclined to go with institutional arbitration or institutional appointments, you're less inclined to go to London or New York or Paris, as you would have seen in 15, 20 years ago, because you now have institutions in different regions that would understand the nuances of the parties, the arbitration, the jurisdiction, and maybe more inclined to give you the sort of diverse tribunal that you would have. So I would say it's improving. I wouldn't say we're there yet, but it's a great improvement. And I'm sure if you speak with people that have been practicing for 20 years, 30 years, they would tell you that we're seeing more appointments coming out of Africa, Middle East, Asia. And, you know, it's greatly improved. That's what I would say the landscape has been.
Okay, that's good to hear. And Anna, how about for you? How does it look?
I find that my generation, meaning early 40s, is already very much diverse if compared to previous generations. And I'm pretty sure that younger generations are more and more diverse. I understand that global arbitrary institutions like the ICC, for instance, have made great efforts toward regional diversity, including opening offices elsewhere, as it is the case for the ICC in Abu Dhabi, Hong Kong, New York City, São Paulo, and Singapore. And looking at the 2020 ICC statistics, I know that their records include geographical diversity of arbitrators of 92 nationalities and places of arbitration of 65 countries. Now, from the perspective of regional institutions, I'm the proof that Peruvian institutions, for instance, have made great effort toward regional diversity, at least within Latin America. As a Brazilian arbitration practitioner, received invitations to join the panel of arbitrators of the Lima Chamber of Commerce and the AmCham arbitral institution. I was also able to reach out to the Mexico chamber, and I should thank the Secretary General Frida Altamirano in this regard, who informed that in the last 5 years, 90% of the arbitrators were nationals of Latin America, spanning Mexico, Peru, and Chile. 7% were European from Spain and France, and 3% were US citizens. This is, of course, explained by the fact that their proceedings are conducted in Spanish and Mexican law applies most times. So it depends on the type of proceedings an arbitral institution is administering, then you will have various grades of regional diversity.
Right, so there is some variation, similar to what Oluwaseun said. There seems to be some improvement, but still not quite there yet. And perhaps a follow-up question for you, Anna. It seems almost trite to ask this question, but I'm sure you will have some interesting perspectives to share. You know, why should we think about regional diversity? Why does it matter, especially for international arbitration?
I think it's important for the legitimacy of international arbitration, but regional diversity has to be adapted to and should be adjusted in light of the relevant elements of a particular arbitration proceeding. And this is key to enhance cultural neutrality, a quality that is greatly appreciated in international arbitrators, as my colleague Yves de Hans has put very well. But of course, regional diversity has to make sense. One has to consider when nominating or appointing an arbitrator, I mean appointing from an institution point of view, one has to consider the party's nationality, the applicable law, the arbitral seat, the language of the proceedings, and not to mention the costs of flying, for instance, an arbitrator to the hearing venue, as often now after the pandemic, hearings on the merits take place physically or in a hybrid format. That's my take on it.
Yeah, and I think it's an excellent point that you raise about legitimacy, which is, you know, kind of key for us as international arbitration practitioners. May, what is your take on this?
For me, the most important thing, I think, is better decision making. Given we all know parties come from different nationalities, legal systems, business practices, religions, I think it's quite important for the tribunal to be as diverse as possible. For me, written submissions and witness and documentary evidence never really cover all of the factual basis for a case. And the gaps in knowledge need to be filled by human experience and kind of human understanding, which will only be broad if your arbitrators are from a diverse background. And just to give you a couple of very kind of common examples. So in certain Asian cultures, you know, shaking your head signifies agreement rather than disagreement. And if an arbitrator for some reason didn't know that, they could make a serious mistake in their decision making when they're listening to witness evidence and witness testimony. And then in some other cultures, you know, looking someone in the eye is a sign of trustworthiness and straightforwardness and honesty. And in some cultures, looking someone in the eye is disrespectful. So different arbitrators can perhaps bring knowledge of the different cultures that come before arbitrators, and therefore add a level of insight and information into the decision making that you wouldn't get if you had a very a tribunal that was all from sort of the same business and cultural and legal background.
Right, yeah, that's really key, isn't it? Decision making, and that's what arbitrators are there for. And so it just makes a lot of sense to have the most diverse and therefore the best decision. Sara, is there anything more that you would like to add here?
Thank you, Roopa. I mean, I would just like to echo what Anna and May have said, which is why is it important that we talk about regional diversity, and why are we actually talking about it here? And I fully agree that it's really related and correlated to an issue pertaining to the legitimacy itself of the process. So when we talk about international arbitration, we're talking about often cross-border disputes with parties from different nationalities, even often different counsel and witnesses from different parts of the world and coming and hailing from different backgrounds as well. And so as such, you want to uphold in a way the philosophy or the rationale of the process itself, the process that the parties have chosen as a means to resolve disputes. But also to the point that May was making as well. I think many of you may be familiar that there has been extensive studies on the role of diversity. And I'm not talking only about gender diversity, and this is probably what I would like to maybe highlight, is that if you look at modern arbitration, which we're currently living, the modern times of arbitration, which is spanning, I guess it's arguable depending on the zone which we're located globally, but it's more or less the past 2 to 3 decades. In the Middle East, it's a little bit less than that, the modern days of arbitration, but we're talking more about the past 2 to 3 decades. So when we talk about modern arbitration, you will notice that over probably the past 15 years or 10 years or so, the talk has been primarily on gender diversity. And I think, I'd like to think that we are now obviously made significant progress on that front, though obviously and arguably not fully there. But I think now we're what I personally call step 2 or phase 2 of diversity, which is a little bit shifting the gear forward. And we're now talking about regional diversity, quite rightfully, because if it's important, its importance as well to the overall decision-making process. This has been obviously proven through numerous studies, not also actually relating only to dispute resolution. When we talk about board structure globally and businesses, it has been proven as well that the more diverse individuals or a pool of individuals you have, the more a better outcome you are likely to gain. And that is even more, I would say, a fortiori, the position when you're part of a tribunal tasked with resolving issues, often multifaceted, with multifaceted layers, with cross-border elements as well.
Thank you, Sara. That was really, really insightful. And I think this point about the improved decision-making, especially in different contexts, not just in arbitration, is kind of proof that this is something worth discussing and moving forward. So we've spoken a little bit about why it's important, but now let's move on to what are some of the most significant obstacles to achieving better geographic representation on arbitral tribunals. So in this phase 2, what is it that is keeping us back? And perhaps Oluwaseun, would you like to start us off here?
I would say that being intentional about diversity in the appointment of a tribunal. So you would be aware of some pledges and some initiatives, and you have arbitration chambers, you have law firms and arbitral institutions making pledges to be to show diversity in appointment. And I would say from my experience, you're more inclined to see arbitral institutions have it as an initiative, and a few law firms, but more of arbitral institutions. And this is why the law firms are important. Parties rely on counsel to advise on appointment where the arbitration agreement provides that parties would appoint. And so if the firm or counsel doesn't have a pledge or hasn't taken ownership or doesn't see the role that diversity would play, it may not be a consideration. And the odds of you seeing diversity in an arbitration agreement are really slim. And so this is where counsel come in. And I believe that arbitral associations and institutions need to move away from, or in addition to the pledges that they've made and the initiatives that they've made, get law firms to see the role that diversity would play, even in the growth of arbitration in their jurisdiction. And so one of the things that we do at my firm, and that I do myself, is to push for diversity in terms of race. So if you're having, for example, parties from different jurisdictions, that may easily help. I think it may be more difficult if you have all the parties are from the same jurisdiction. It may be a little difficult to convince as to why you're going to Asia if two parties are from the European Union. But again, like I said, parties are relying on counsel and they are relying on arbitral institutions. And once we take global ownership of it, I believe that we would be able to scale through the first obstacle of diversity in appointments.
Thank you, Oluwaseun. And it's interesting what you say about the relationship between counsel and the appointment process. So May, perhaps a question for you. How does the diversity of the appointing parties, i.e. law firms, influence arbitral appointments with a specific focus on Asia? Does the lack of diversity in one, so law firms, automatically lead to a lack of diversity in the other? Or what is the relationship in your view?
It's quite a complex question. In Asia, we do have arbitration clauses that will specify certain requirements. So for example, qualification or language skills, and then actually the sort of contractual requirement leads to more diverse panels in Asia, probably than, as Sean said earlier, in other regions, because there is a built-in mechanism requiring diversity. So in my head, when I'm appointing, I do have various lists of people that fall into these different buckets, linguistic skills, legal technical skills from different jurisdictions that are needed. But the problem then arises is that you end up having diverse panels, but you end up appointing the same people to the job. So the same people get more and more experience, and we're not widening the pool. One recent phenomena, at least in Asia, and I think it's probably happening elsewhere as well, is that institutes are now recording how many new arbitrators are being appointed by that institute, either by parties or by the institution, and sort of trying to grow the pool, which I think is an excellent initiative. The other thing that us lawyers, we really have to fight against is that we're just by nature really conservative people. We don't want to take risks, particularly with our clients' cases. And so we tend to go for someone who's got experience sitting as an arbitrator. And then it's very difficult to get your first case as an arbitrator because, it's catch-22. You need experience, but you're not getting experience unless you've sat before. And my answer to that is just to talk to the institutions. They are very supportive, and they will, if they know you're interested and you're ready to take an appointment, they will go out of their way, in Asia at least, to find a suitable first appointment and then support that new arbitrator through it quite a lot initially by giving much more pointers about procedure and how to deal with that difficult issues and difficult parties.
I would also say, in addition to what May has said, your clients depend on you, and you're not exactly excited about making your case a guinea pig, in order to achieve diversity. And if your client is asking you to make recommendations, what would help would be to ask, would be for, their CVs, their resume. And especially now that if you're having an energy dispute, it could be quantum in energy, for example, or if you're having a construction dispute, it could be negligence. So the downside with that is you may not find a lot of people that have that sort of specialty within specialty. But, you know, if you ask for CVs, I think to some extent you would have fulfilled the duty of care to ensure that you've struck a balance between diversity and experience. And it's not in all cases that it has to be either of the two. You can get both. So I think, lawyers advising parties just have to be daring to, take the bold step, go beyond the well-known names and, ask would-be arbitrators to send their CV. And I think this is very important because the established and already experienced arbitrators are going to retire someday. And so we need to prepare the next generation, and we can't do that if we're not bold and courageous to, take some measured risk, and emphasis on measured.
Yeah, I completely agree with that. I think in the past, you might just spend 10 minutes on it and then come up with 3 obvious names and go with one of them. I think today, lawyers are much more conscientious of sitting on that decision for a bit and doing the research that you just mentioned before making a recommendation.
Right. So to kind of counteract this risk averseness that we have as lawyers, is there something to be said? How can we improve the visibility of the existing pool of candidates? And in this context, maybe you can answer also the question from the audience, which is, how does one become an international arbitrator? Is the global market open for foreign lawyers? Anna, would you like to answer this one?
Yes, thank you, Roopa, and thank you, the anonymous participant, for the good question. Yes, I understand that opportunities lead to opportunities. So the more diverse pool of rising arbitrators we have with opportunities to arbitrate, a more diverse pool we will have of more senior and experienced arbitrators in the future. So it's a virtuous cycle, as I was saying. To answer the question, I guess there is no recipe, to become an international arbitrator. I wouldn't say you have to start by doing this or that. It's also not only about having the technical capabilities and the passion for it, because if you are not passionate, this is not a profession suitable for someone. But I think I give you the example of a former colleague of mine, Valeria Galíndez. She's Argentine background, but she was raised in Brazil, and she spent some part of her childhood in France and perhaps other countries, because her father used to work for a multinational, an Argentine or French company, I can't recall. But in any case, she started doing great job as an arbitrator in domestic proceedings. And then now, because of her cultural background and the languages she speaks, now I see that she's doing many international arbitrations, and so other persons will start already in a very important arbitral center, like they are based, say, in New York or in Paris or in Geneva, and in the Middle East or in Dubai. That's also an important center. But in the East, of course, there is Singapore, Hong Kong. But in any case, you may be lucky to be already based in an important arbitral center, but it doesn't necessarily mean that you can't do differently. You can be based somewhere else, in Brazil, let's say, and then you expand your practice by doing a very good job and also having good connections, and also with arbitral institutions. I'm sure that for Valeria, I think she was ICC-IAF, representative for a long time, and she had so the ICC, she had a few ICC appointments at the start of her career as sole arbitrator. But I'm sure that there are many ways. There is no recipe.
Yes, thank you very much, Anna. I think I would agree that there is no recipe, but I think there will definitely be some ideas that will come out of this discussion on how to move forward and try to build a profile as an arbitrator. Sara, I would just like to give you the opportunity to explain, the MENA perspective in terms of obstacles. Then we can move on to the way forward.
Yeah, thank you, Roopa. And maybe just to put this very interesting and insightful discussion into perspective is that when it comes, I guess, to appointments, right, I would like sometimes to think about it from an economic perspective, right? So if you adopt, I guess, an economic theory to appointments, it's really all about demand and supply, right? So it's all about, you know, how much demand is there and then how much supply is out there. And I think, you know, often we talk about, you know, getting your first appointment. And that is obviously very important for several reasons, because also if you look at statistics, you will often see that by and large, first appointments, especially when they go well, obviously, often lead to repeat appointments thereafter. And they're in a way often perceived as that key to that locked door, which opens the way for further appointments down the line. But I think one thing which is worth of noting as well is that first appointments obviously are one thing, and it's important to try and work around getting there. And obviously, once you get there, obviously, you're going to have to work around making a good job, because if you don't do a good job on that first appointment, regardless of the considerations that's out there, and I guess many of us on this talk today would agree that often first appointments as well comes with their own side of challenges as well. They're not necessarily very straightforward sometimes, and often carry certain procedural, I would say, traps in them that you should be ultra cautious with the way you address them. But one thing which also I wanted to share from a MENA perspective is that often when you talk about first appointments, that is obviously, I guess all of us would have a consensus on that is quite important. And if one is to venture out in a career as an arbitrator, then obviously you want to make sure you get that first appointment, and two, that you're going to do it well. But I think the question begs itself in emerging markets and the Middle East and North Africa are a very good example of it, is in terms of, I guess, supply. So when you look at the supply of arbitrators, you will often see as well that historically as well, there has been a level of underrepresentation and under-availability of a qualified pool coming and stemming and hailing from the region, who are able to act and sit as arbitrators. So I think one important factor, I guess, pertaining to the obstacles in achieving greater regional diversity, and I guess from a MENA perspective, I'm not sure whether it applies to the other regions we have on the call here today. But one important factor is, yes, we often talk about first appointments. But I think one important factor is when we look at it from the other side of the lens, which is the supply. Do we have enough supply? And most often, at least, you know, I've been here for almost a decade as a professional, and even more than that as someone coming from this region. But I can tell you that we have an issue with the pool that's available. And unless you tackle that issue, which is adopt an ex-ante approach, which is to tackle the issue of the pool, well, you're still going to have, unfortunately, obstacles. So you want to be able, I guess, and I believe Anna talked about this in terms of providing some form of a succession plan, you know, on the pool of arbitrators for many generations going forward, where you want to make sure as well that the new arbitrators, and I think many of you might know that there isn't really a fixed age or a set age to become an arbitrator. It's quite flexible. You have first-time appointees at the age of 50. You have others at the age, you know, in their 20s or late 20s or early 30s, and that varies. But I think, you know, the question really ties up, and this is often an obstacle that I personally see in the Middle East region, is often, unfortunately, you end up more or less with the same candidates or the same usual suspects because of the lack, unfortunately, of an available pool. So the question then becomes, how do we grow that pool?
That's very interesting what you say about the lack of pool. I had always assumed that the lack of regional diversity comes in part from a lack of visibility. So I guess that leads us nicely to our next segment, which is, what can we do? And Sara, I guess this question is for you. what can we do to tackle this pool? What are the ways that we can move forward in this respect?
Well, I think, like May said, we have to think a little bit and try, I guess, at a personal level, at an individual level. We have to try and be, I guess, a little braver in the way we proceed. I fully agree with May. We tend to be, as lawyers, quite risk averse. And I'm not sure about you, but I always try to see first if the client has any proposals, because you don't want to more or less have any sort of, you don't want to sort of actively partake or impose an arbitrator on a particular client. So it is often, do you have any candidates? If not, well, you want to think it through and then put a list. But I fully agree also with May is, I think there has been now more effort, which is quite fortunately, I guess, not always, but by and large, there has been more concerted and reasonable effort to try really and diversify that list, which lands on the General Counsel's desk. And I think where in the past we just put a list of 3 to 4 names. I know now personally that at my level, I really give it a lot of, conscious effort to try really and put a list which is equally, I guess, competent, qualified, but also, diverse. And that is not to say that, I have to obviously make sure every time that I have a female arbitrator, or that I have to have every time someone from an underrepresented or minority group out there, or from a specific region. But I guess first and foremost, the factual matrix of the dispute and the issues and what does it entail. And then I would move forward to, assuming all those candidates have the required skill set, well, can I really then make a conscious effort of putting forward, a new candidate, or putting forward someone, who's probably less visible, or, not necessarily part of that group that's always, getting repeated upon. So I guess first and foremost, it's really us at our level taking charge of this and trying to change. And Roopa, to the point you were making about, the possible interactions or correlations with partnerships of law firms, and then the dilemma of diversity and the equation of diversity across, the entire spectrum, right? Because diversity is obviously carries different connotations, from gender to nationality to ethnicity, etc. And I think, at least from personal experience, is that unfortunately, we are not there yet in terms of partnership at law firms. There is obviously effort being conducted, and that's great because, we've reached that level of awareness. But I think, and I speak at least for myself, that, when you're part of, a minority, and I'm talking about female partners, for example, at a law firm, you then take, I guess, more of a concerted and a more of an aware approach, that you definitely want to try to do something at your level to try and promote regional or gender diversity. And I think sometimes when you go through an experience, you want to try at least to change the way that experience has happened in a way, and try to do good and be well. And I guess the second thing where, we could try and make change is, obviously, I think all of us would agree, there has been a lot of changes in the positive sense of the word from an institutional perspective. And I say this wearing my hat as an ICC court member. And I can tell you that there's really a lot of effort and thought put into the nomination and appointment process. And there's a lot of consideration given as well by the ICC court towards getting the right candidate for the case, but also weighing in all those different factors, one of them being obviously the regional diversity, I would say, factor.
That is very good to hear, and particularly since the ICC has such a global reach, I think that will be very important going forward. In this context, Sara, what you mentioned about counsel having to do more, perhaps something interesting that May could speak about is the Delos arbitrator database that I understand, May, you have been instrumental in developing. Can you tell us a bit more about this database and how it's shaping up in terms of contributing to improved geographic diversity?
Yes, of course. We found at Delos that, well, firstly, Delos is an independent arbitration institution, and it is new and has developed really great resources for arbitration practitioners. And one of them is this database, which is intended not for, you know, the sort of well-known names, but rather for young aspiring arbitrators or arbitrators from regions that are sort of less well-known, where there are less opportunities for publicity and getting their name out. And what's different about the database compared to sort of other panels of arbitrators and things like that is that we're trying to make it searchable by many more fields than what you would normally find, which is just, I think the typical one would be, you know, gender and nationality, and then maybe legal qualification. So we're throwing in things like language, sector experience, geographic expertise, you know, in addition to nationality, because I'm, as you mentioned earlier, a Malaysian national, but I'm not qualified in Malaysia to practice. I'm only UK and Hong Kong qualified. So it's meant to be very comprehensive, search functions, and you can cross search different functions to bring up different candidates that you might not have considered before. But, and this is a plea to all our audience who are interested in a career as an arbitrator, the tool is only as good as the names that we can get on there. So please do check it out. It's a really useful tool. And if Roopa, you don't mind, I might try and put this a link to the database onto the chat function so that people can see and hopefully sign up.
Yes, please do that. I think it sounds like a very interesting tool that will hopefully be very helpful going forward to address these challenges. Oluwaseun, is there anything that the institutions are doing that you would like to comment on, you know, from a West African perspective? Sorry, you're on mute.
Yes, we have the Lagos Court of Arbitration has about 3 pathways, or would I say 3 initiatives, that if you're pursuing a career in arbitration, or if you're looking for diverse arbitrators, would help. So first of all, it's important I mention that membership of the Lagos Court of Arbitration is open to the international community. So it's not limited to West Africans or Africans. And so the LCA has a panel of neutrals, and I would say it's one of the most wholesome representation of diversity and expertise. And you, of course, have to be a member of the court to be able to register as a panel of neutrals. And membership is a stipend, and you would typically have to provide your CV just so that the institution can identify your level of expertise and be well informed to make recommendations to disputing parties. The court also has a medium and small scale scheme, and I think this is something that young arbitrators would be interested in. The medium and small claims scheme are for claims not exceeding about $20,000. And honestly, they may not be of interest to established and leading arbitrators because of the value of the claim. And so this is an opportunity for young arbitrators to build your expertise. Of course, your fees are capped, but that may just be the sacrifice you have to make to, you know, get some expertise on your CV. Again, you could come in, you could be appointed on that scheme as an arbitrator. They are usually sole arbitrators because of the value of the claim. And there's an opportunity to serve as a tribunal secretary as well if you're also appointed. Now, because this scheme is an initiative of the Lagos Court of Arbitration, the court is appointing the tribunal and tribunal secretary, if any. So the court in this instance is not relying on parties through their counsel to make appointments. And so and I've seen this help. I've taken advantage of it. And I've seen this help people who just want to get a leg up, you know, in the arbitration community. That's one of the schemes that the LCA has. And they also have a tribunal secretary's track. You register, you're on their database, and I'm not aware that the LCA has gone outside that track. I'm not saying they don't appoint outside the track. I'm just not aware that they've gone outside their database of tribunal secretaries to appoint tribunal secretaries. So they're very intentional. They are very intentional. Of course, the tribunal secretary database, they rely on it both for the small, claim scheme appointments and the large, claim scheme appointment. This initiative has been in place for some years and is in collaboration with the Chartered Institute of Arbitrators. And I'm sure if you speak with a couple of practitioners from West Africa, they would be able to tell you how this initiative has been of benefit to them. So that's what I could say for West Africa.
Yeah, that sounds like a really, really good initiative, because obviously, it's hard to appoint someone if you've never seen them in action. And this goes to the point that Sara was making about, the difficulty of getting a first appointment and then repeat appointments. May, then, what about in Asia? Are there similar schemes?
Yeah, there are very good schemes in Asia, quite similar. So for just speaking about SIAC and HKIAC, and which are the institutes that are sort of probably best known internationally, both of them have a sort of more junior panel. In the HKIAC, it's called the list of arbitrators instead of panel of arbitrators. And SIAC, I think it's called the reserve list. And for those second panels, they are very much that the whole point of it is to bring up a new generation of arbitrators, starting off with doing sort of more smaller cases where the experienced arbitrators are not so interested in taking on sort of, claims lower than 1 million or 1 to 2 million. That's exactly how I started. No years of qualification needed for HKIAC. I think SIAC does need 10 years. CTAC, which is the other big institute doing mostly China-related disputes, I think it's 7 or 8 years. Just for those of you out there, being arbitrated for the first time is complicated. The institute knows it's your first time or one of your first times, and they will help you through it more than an experienced arbitrator. And small value claims don't necessarily mean that they're straightforward. Oftentimes they can be as difficult and more difficult because they're small value. You have to solve those issues much more efficiently than if you had, very experienced and expensive counsel and big teams of lawyers on each side assisting you to get to the decision. So it's definitely challenging, but they wouldn't be appointing you if they didn't think that you had what it takes. And remember, you're not alone. The institute will be there to help, and the arbitral community in general are very keen to help guide new arbitrators through their first cases.
That's great, May. So it looks like in Asia as well, there's really a movement to move things forward. So that's very good. Maybe we can move a little bit away now from what institutions are doing and speak more broadly about the arbitration community as a whole. Sara, as an Arbitral Women board member, can you perhaps tell us a bit about the steps that Arbitral Women is taking?
Sure. So for those of you who might not be very familiar with Arbitral Women, it's a Paris-based non-profit organization which was founded in 1993 by a group of female practitioners, namely Louise Barrington and Mires Philippe from the ICC. And not a lot of people know that they actually had around many other women that on the day of the establishment of Arbitral Women that have supported such an initiative. One of them actually being Claudia Solomon, the current president of the ICC court. And so the role of Arbitral Women in a nutshell is to promote the visibility of women in international dispute resolution. And obviously the positioning of Arbitral Women obviously is clear. It's positioned with respect to gender diversity. But that is not to say that arbitral women doesn't give weight or importance to the regional or ethnicity or nationality diversity as well. And so, you know, there are, over the years, there has been several initiatives that have been laid out there. And I think I can speak for, you know, having been the first ever Middle East-based member to be elected to the board in 2018. So can you imagine it took around 25 years to have a member from the Middle East region elected to the board of arbitral women. There's a lot of work obviously happening and effort both by the board, but also the entire membership of arbitral women geared towards promoting the visibility of other women in arbitration, but also by and large dispute resolution at an international level. And the purpose of it is really to support and give more visibility. So we go back again to one of the main issues that often we encounter in the field of international arbitration is obviously helping individuals coming from a minority group or from an underrepresented historically region gain visibility. And so the focus with arbitral women is obviously to do that, but to do it also with an emphasis on gender diversity. And there has been obviously many events that have been organized globally, not only in specific regions. And there's often a lot of emphasis put by arbitral women on making sure that regional diversity is well presented in those events. So for example, if arbitral women is to organize an event in the MENA region, then there will be a lot of effort and consideration put forward with regards to making sure that the speakers, for example, who are conveying the message are majority individuals coming from this region. And that is obviously to say that there is obviously a very high correlation between gender diversity on one front and national and ethnicity and other considerations which regional diversity ties up into them. There's also obviously mentorship programs that have been developed, and Lizzie Chan, who is actually has brilliantly put forward this series among a panel of other stellar women. ARBinBRIEF, Lizzie Chan is also a very active board member as well of Arbitral Women. So I think I'd like to think of Arbitral Women really as a gathering place or a platform where many also brilliant and talented women get together, promoting each other, but also where many interesting and much needed ideas come to light as well. And I guess ARBinBRIEF is a very good one.
Thank you, Sara. And I can confirm, so I'm a mentee in the Arbitral Women Mentoring Program, and I can definitely confirm that it's really great and has helped me a lot. There are quite a few questions in the chat. So I think I will maybe go in order. The first one is for Oluwaseun. It is, what qualifies a young aspiring arbitrator to be an arbitral secretary?
So I think it was Anna that mentioned that it's hard to get just one specific list of qualifications you need to have. It's non-exhaustive, but what I would say would help you would be having some experience in arbitration, either as counsel or even if you've shadowed an arbitrator. And shadowing an arbitrator would be, you don't have a formal role in the proceedings as counsel or tribunal secretary, but the arbitrator has gotten the consent of parties for you to sit in and just observe how proceedings go. I am fortunate to have worked in a law firm as arbitration counsel, so that may have given me an edge in getting tribunal secretary appointments. But again, you would have some institutions that may have their own requirements, but it's not cast in stone. I would just say do what you can, write articles. And if you say you're a student, you probably would be a millennial or Gen Z. There are podcasts, you can write articles, you can attend conferences, you can also have a mentor. And I know Sarah and May have mentioned about the different initiatives, and Roopa as well about some mentorship schemes. So it may be easier to have a mentor who would help you in terms of recommending you, or have you sit in as tribunal secretary where they will provide the support. But again, there's also the institutions as well who have a track. So if you could look that up and see if you meet any of the requirements of, you know, various institutions, then that would be a good start as well.
Thank you.
Roopa, can I just add to that the HKIAC have got a really excellent, and I mean really excellent program for training future tribunal secretaries, because I've been a beneficiary sitting as arbitrator to have a number of tribunal secretaries that did that program, and you know the level of support that they can then provide and their knowledge of what makes a good tribunal secretary and what they're expected to do is really, really great. So I'd encourage whoever asked the question to look at that.
The Secretary General of the HKIC is also in attendance, so thank you to the HKIC for providing all these good initiatives.
Yes.
So we have also a question from Nu Huang. This is mainly to Sara, but the others can also feel free to comment. I'll just read the question for the benefit of the audience. We discussed geographical diversity in a panel at ICA recently, and participants from the Middle East were reporting that they routinely see cases involving two parties from civil law jurisdictions in their region heard by all English QC tribunals, and that this is a result of their clients' insistence. Do you agree, and do you manage to convince your clients otherwise sometimes?
So thank you, Nu-Hang, for this, I guess, important question, right? So this goes, I guess, to the point I made earlier relating to the pool, right? So historically, when you look at the history of arbitration in the Middle East, the first sort of arbitration started erupting back in the 1950s of the, last century. And at the time, those were primarily related to oil and gas disputes over pipelines in the UAE, but as well as Saudi Arabia. And historically, the arbitrators that were tasked with determining those disputes were English-trained gentlemen. And this has obviously continued thereafter. And some of you might know that there's a lot of historical ties as well between some countries in the Middle East as well as England. And so this goes back again to the issue, which is there's lack of the lack of pool that I mentioned earlier in the talk. And then by the same token, I guess the availability of a qualified pool who is predominantly obviously English speaking, because most of these disputes were conducted in the English language, because most often it was between a foreign company with a state-owned entity in the Gulf Cooperation Council region. So historically, there has been a lot of impetus put on resorting to English qualified attorneys or barristers or even King's Counsel. And this has led obviously to have the proceedings, even though, for example, at the outset being civil law, I guess embedded with civil law traditions, such as, for example, having the applicable law being from a civil law jurisdiction here in the Middle East, which is predominantly the case, to obviously running the proceedings then as though they're English or common law style proceedings, which has led thereafter to bringing on board obviously counsel, either as lead counsel being from English qualified or being as a co-counsel with a firm from the Middle East. And that obviously gives comfort, and that gives psychological comfort. And to the point that Nu-Hang was making in the question, it's often the case that parties, especially in a dispute, they want to be able to bring on their game. And so when they see, for example, that a party has brought forward a King's Counsel and maybe, the issues of a dispute might not even warrant it. I'm not saying that you do not have to resort to QCs or KCs to be more accurate. let's admit it, they are very competent colleagues who have received a very thorough and able education as well as part of their qualifications. But it is not to say that every dispute would require the intervention of a KC as part of either an arbitral appointment or even as counsel. But you do have, I guess, from a psychological comfort perspective, certain clients, when they see that the other side, for example, has appointed a KC, then wanting to try and speak the same language, so they would bring forward as well a KC as counsel. And then when the other side sees that, well, they want to also replicate because they want to bring forward the same, I guess, ammunition to the game, which is, as part of the dispute. And so I guess I'm not saying it is completely wrong, but it's not always adequate for the specific type of certain proceedings that are being conducted. And so it does take, I guess, a little bit of effort by counsel to try and, rationalize the client when he or she ventures out to say, I would also like a KC on board, to try and explain that, probably the case does not warrant it. And I guess that also leads to, the level, I guess, of comfort, trust, and confidence that the client has in your own professional capability as well, and in the trust they have in you of being able to take the case forward and to present it in an able and capable manner, regardless of whether or not a KC. But maybe to point you all maybe to a very live debate in the Middle East region. There was a GAR live a few years ago, and the debate was about whether the Middle East arbitration should only be heard by Middle Eastern arbitrators or not. And obviously this is another dimension, and this is beyond the scope of today's discussion, but that is obviously a very live question in this part of the world, and I'm grateful for Noham for having raised it. But also in a way, this historically dates back to the lack of an available pool back in the days when arbitrations started flowing in this part of this world.
Thank you very much, Sara, and also to Noham for the very interesting question. So that's given us a lot of food for thought, but unfortunately we are coming to the end of our hour. So I would just like to ask each of the panelists to give their advice from the perspective of an aspiring arbitrator from an underrepresented region. What if you could give one piece of advice, what would it be? Anna, please go ahead.
Thank you, Roopa. Yes, I would say don't be afraid to do the asking. I think that's the one thing that perhaps sometimes we're a bit shy to do, but it's key, because if you do the asking, let's say, if you want to become an arbitrator in Latin America, say I'm from Latin America, so I can speak for that, you can apply and you can map the regional institutions, and you'll find out that you can apply to become member of their panels of arbitrators. If you do that and you follow up and you reach out to the right people, you have to do your homework and discuss with your colleagues whom you should ask. Also, it's important whom to ask, whom to send the application, with whom to follow up, and then you will become perhaps a member of a panel. And this will make, as a consequence, will lead to appointments as a member of ad hoc committees to decide on the challenge of arbitrators. This is very typical in Brazil, for instance. And then you get visibility in a small little case about the challenge of against an arbitrator. And then you will have some visibility vis-a-vis other colleagues. And at some point, because you've been helping the institution, it's a bit of a volunteer work. It's not very good, very well paid. You at some point receive perhaps an appointment from the institution or from other colleagues. So do the asking. That would be my message today.
Thank you, and I think that's very important. A lot of people just don't ask. Oluwaseun, how about you? What's your piece of advice?
I would say that if you prefer the organic approach, and the organic approach I mean by having someone hold your hand physically, you may want to explore having a mentor. I met my mentor at the CAP conference in 2009. And we just had a chat. I made sure I followed up after the conference. And I spent some time shadowing, and then got some recommendations and referrals. you have to be intentional. You have LinkedIn. You many years back, people would send letters, people would send emails to law firms or arbitrators or institutions. Now technology has breached the gap that you may have, and you could be in India and have your mentor in Brazil. You could be in London and be on the list in the database in Mauritius, in Kenya, in Kigali, in Lagos. But you have to be intentional. I find that people are more inclined to support you when they see the steps that you have taken yourself. And you have to understand that there's a large pool of people pursuing the same opportunities. And so institutions and individuals don't really have as much time to be chasing you. So you have to be intentional. And I believe you get the support when people see the intentionality from you.
Thank you. May?
I support everything that's been said before, so I might use my tip to bring something new to the table. I would say be an advocate in your hearings where you're counsel. Even if you're not the most senior person, ask for an opportunity to do some advocacy, because we never remember who is in the hearing except for the people who were brilliant advocates. You'll be remembered by counsel on the other side, by all the clients in the room, and by the arbitrators. And that's how I got some of my appointments.
Very good tip. Sara?
I'll just keep it brief and maybe endorse whatever was said. And I'll just say, believe in yourself, do well, and trust the process.
Thank you very much. Very concise. I love it. So thank you to all of you, Oluwaseun, Anna, Sara, and May, for your great contributions to the discussion. It was really insightful, and I learned a lot, and I hope that the audience did too. So now we can start our season 2 episodes with a lot of food for thought. The first episode will take place on the 12th of October, and we will shortly announce the first episode with more details on our LinkedIn page, so you can follow that to stay in the loop. And just very finally, I would like to thank our partner organizations, Delos Dispute Resolution and the Arbitration Pledge, as well as all of our supporting organizations. There are just so many, so I cannot name them all, but we are really grateful for your support. So thank you very much and goodbye.